Mr. Stone, I have a question about this suggestion that he could exit after the trial court denied the evidence, because, I mean, maybe I'm thinking about this incorrectly, but in a procedural due process claim, the claim is that the procedures given by the state were not adequate to protect, to ensure an unconstitutional deprivation of the liberty interest. And in the case of Article 64, the full run of the procedure includes the trial court and then the direct appeal in a capital case, the direct appeal to the CCA, and then we can have this dispute about whether the petition for rehearing is included or not. But I don't understand why he could exit at the trial court stage, because the way Article 64 is set up to ensure that he's not deprived of a constitutional right erroneously is to give him the opportunity to appeal to the CCA and let the CCA correct any mistake that the trial court has made. So am I understanding that correctly? I just don't understand how the cause of action exists until the procedures have failed him.
2 points, Your Honor. The more direct one than the less. The more direct one is, I think he makes a different kind of due process claim. His claim is not that the processes were insufficient. His claim is the processes are basically unfair. And when an individual says the state has subjected me to a process that is basically unfair, it cannot possibly give me a fair shake, that person has a full and complete present cause of action at that moment regarding whatever the regime is that they say they've been tried to, which is probably partially why my friend on the other side specifically agreed he could, in, for example, Justice Alito's hypo, exit the state court system and begin his suit in federal court whenever he liked.